Hello, good evening, everyone. So, welcome to this session in which we are going to discuss the importance of government laws for CLAT preparation. So, if I am audible to all of you and if the screen is also visible to you, please let me know in the comments. All right. So, see, when we prepare for CLAT, we always tend to see the portions of syllabus in watertight compartments. But I must tell you that it is not the right strategy going forward. Having seen the previous year papers of CLAT and the way the new pattern has evolved, I can tell you from experience that there are certain habits that if you cultivate and if you do them right, you can actually end up in a very good place in CLAT exam. So the purpose of doing this session is that most of us, while preparing for the CLAT exam, we tend to neglect the past trends and we tend to neglect the importance of laws, not only for legal reasoning section, but also for GK section. Now, that is the most important thing. So, just like I told you in one of the previous sessions, that the value of general knowledge is not only to be felt in the GK section of CLAT exam, but is also somehow important in your legal reasoning, in your logical reasoning, and somewhere in your English section as well. So that is the power of newspaper reading, that it can have such a vast impact over your overall preparation. Now imagine if you could read one document every day for just 1 to 1.5 hours or maximum of 2 hours, which will cover almost two sections of your CLAT exam directly and at least one more indirectly. What would you call that document? Or how valuable that document would be for you? Of course, it's like a one stop solution to all your preparation problems. Of course, guidance has to be there. Of course, coaching material has to be there. All those things are there. But if you think of getting a rank, then the level of personal effort that you have to put in and the level of personal attention that you have to pay to these type of value addition things is something that you should be worried about, is something that you should work on. So today we will see that when you read newspapers or when you follow news, how you can actually end up knowing the entire exam, almost the entire exam. I can tell you with conviction that if you study newspaper pretty regularly and if you follow all the relevant news and all the guidance, you'll be surprised in the examination hall. You would have gone through each and every passage, be it in general knowledge section, be it in your legal reasoning section. And somehow, because of reading, all that reading, and again, I must tell you, following news is different from reading books. Because when you follow diverse news, number one, your sphere of knowledge widens. Because when you read a book, you know about only one single subject. But when you read a newspaper, you read sports news, you read political news, you read history related news, you read international relations, economy, geography, and whatnot. So, the kind of mental makeup that a newspaper is able to give you, nothing else can. That is the importance. And also, today we will see that how and which government laws you must focus on. I will also give you certain recent examples. Recent examples means in the past few months, certain events that have happened which influence paper setters, which influence the way various papers are set. So that also you should pay focus on, right? So let us just start with it. So my name is Manish Mittal and I am the general knowledge faculty with Hitbullseye. So first of all, if we see the importance of laws for CLAT or CLAT exam, now there is a misconception about this, that laws, or you can call them anything, you can call them drafts, then there are rules, then there are bylaws, then there is constitution, all these, or it may be, it may be an amendment, or it may be, some law may have been repealed. Anything that has happened to a rule, a law, a draft, anything that is included in this particular topic. So one misconception about this particular topic that students have is that this is only and only important for your legal reasoning section. Let me tell you, it is not 100% correct. When you read laws, it not only has an impact on your legal reasoning section, but it somehow also impacts your general knowledge section, because it is actually not a watertight compartmentalization. There is nothing that the CLAT paper setters have told us, or that we know from experience, or that like nothing is mentioned in the syllabus that tells us that news even remotely related to any of this cannot be asked in GK. No, it is not there. Therefore, laws have actually a domino effect, not only on legal reasoning, but also on general knowledge. Sometimes, if, up to some extent, I'm saying sometimes up to some extent, even on logical reasoning as well. And if you really follow news to that with that much dedication, then it may have even impact on your English section as well. Because mind you, CLAT exam is no more the exam it was a few years back. It has now become a reading test. It has become a reading test. The exam is so lengthy, they are testing your ability to comprehend, they are testing your ability to understand. So they are not only looking for young lawyers who can just mug up facts, who can just know the tidbits of information from here and there, and they can just reprocess it. No, this is not what they're looking for. They're looking for someone who can understand what is written, can comprehend it in different ways, and can actually process that information and come out with an outcome that is well thought out, that is reasoned, and that is able to be produced in a proper manner in the court. That is the kind of mindset they're looking for. Right? So this is the mindset with which you should proceed. That what they are looking for is the processing of information. They're not looking for a rote learned mind. They're looking for someone who can comprehend what is written, who can understand it, and who can actually, with a reasoned mind, with a logical mind, come out with an outcome which is well thought of. And that is possible only if you have diverse reading habits, if you pay focus on horizontal as well as vertical dimension of reading. It is important only then. So the importance of laws for CLAT has to be seen in that context. That laws are not only important from your legal reasoning section, but they also have an overarching impact on your general knowledge section. And sometimes they may help in your legal reasoning and GK section as well. We will see this with an example. So their weightage in legal reasoning section is undisputed. You get some 35, around 35 questions in your legal reasoning section, and most of them come directly or indirectly from the laws. We will see, we will analyze the CLAT 2020 paper, and we will see which all laws are there that you should pay special attention to. And then I will also give you some recent examples from the last few months of current affairs, from which where various laws were in news and how questions can be asked from those. So let us first analyze that paper and then we will move forward. So if we see CLAT 2020, in the legal reasoning section, there were two passages which were based on Constitution of India. Now, Constitution of India is the most important law that India has, the most important law. It is the basis for all other laws. In other words, we can call it the supreme law of the land. There is no other law which is above the Constitution of India. Now, when we say that it is a supreme law, what it means is that it is above all other laws, that it is above all other laws. And in other words, we can call it that all other laws are below it, are below it. So when we combine these two meanings, it simply comes to the conclusion that if any law or any provision of any other law comes into conflict with any of the provisions of the Constitution of India, then that law or that provision shall be declared null and void, and not vice versa. For example, the Constitution of India has fundamental rights in Part 3 of the Constitution. Fundamental rights. Now say freedom of press is a fundamental right. Freedom of press is a fundamental right. Say the government passes a law that restricts the freedom of press. The same law, when it will go for judicial review, now the task of the judiciary at the first instance of prima facie is to test that particular law at the touchstone of constitutionality. Now, when the Supreme Court will test that law on the touchstone of constitution, it will observe that the law and its provisions goes against the fundamental rights, the fundamental right to freedom of press. So now the judiciary will again see whether by removing that particular restriction in the law, the essence of the law is being disturbed or not. That is what we call the doctrine of severability. The doctrine of severability, that whether by severing the law from the contentious provision, the main purpose of the law is being hindered or not. So say if by removing that only provision, the entire law is being defeated, then the entire law shall be declared null and void by the court. But if that particular provision can be separated from the entire law, and that only provision, if nullified, will not impact the rest of the law, then only that much of law shall be declared null and void and not the entire act. In simple words, anything and everything that comes into conflict with any provision of the Constitution shall be declared null and void by the court. This is doctrine of severability and the test of judicial review. So this tells us that Constitution cannot be violated at any cost. If any law is in conflict with Constitution, the law has to go, or that provision has to go. So that is the importance of Constitution of India. Now on Constitution of India, in CLAT 2020, we have two passages in the legal reasoning section. First passage is on Article 20, Clause 1. Article 20, Clause 1, that talks about ex post facto criminal legislation. That actually prohibits ex post facto criminal legislation. Now, what it means is that Article 20, Clause 1 debars the legislature from passing a criminal law from backdate. That means, for example, if on 1st of January 2021, I am playing football, right? If on 1st of January 2021, I am playing football, and at that time, playing football is not a crime. But on, say, 10th of February 2021, the Parliament of India passes a law that criminalizes playing football. That is fine. Even that is fine. But in the law, there is a clause which says that this particular act shall come into effect from 1st of January 2021. That means ex post facto, or from a previous date, the law shall come into effect. Now, when I was playing football, I was not even remotely aware of the fact that in the future, sometime or someday, the government will criminalize this particular activity. So I was clueless. Now the government or any authority cannot punish me for that. That means if a criminal act is to be declared, it cannot be done from a backdate. This is what Article 20 Clause 1 does. It prohibits the government from passing a criminal legislation from a backdate because it can be used for vendetta. It can be used to selectively target someone. Therefore, this particular provision is not there. However, the provision applies only in case of criminal legislation. Civil legislation can be applied from a backdate. For instance, if we take the same example, the government on 10th of February 2021 says that a person who doesn't pay a particular tax, like tax defaulter, shall be penalized starting from 1st of January 2021. Like a civil offense has been declared, and it has been declared from a backdate. Now, in this case, it is perfectly valid because it is not criminalizing tax defaulting. It is a civil offense. And the difference between civil and criminal offense is that in criminal offense, there is mens rea. The intention is malified. Whereas in civil offense, there is no such thing. Also, in criminal offense, there is the provision for incarceration. Whereas in civil offense, there is provision only for fines. Therefore, a civil offense can be declared ex post facto, whereas a criminal offense cannot be. So on this particular Article 20 Clause 1 of the Constitution, there was a passage in legal reasoning section of CLAT 2020. This was one. The second example is of Article 32. The second example is Article 32 of the Constitution. Now, Article 32 of the Constitution, I think, is one of the most important articles of the Constitution. In fact, Dr. B.R. Ambedkar described Article 32 as the soul of the Constitution. He described Article 32 as the soul of the Constitution. It falls under Part 3 of the Constitution, which is fundamental rights. So Part 3 that stretches from Article 12 to 35, it has Article 32 as the right to constitutional remedies. So basically, why did Dr. B.R. Ambedkar describe this article as the soul of the Constitution? Because all the fundamental rights mentioned from Article 14 to 31 are directly enforceable in the Supreme Court of India by virtue of this particular article. So there are basically 5 writs that are there in the Constitution of India in Article 32, which are mentioned under Article 32. Number 1 is the writ of habeas corpus. So habeas corpus means to have the body. It is against illegal detention. So under Article 22 of the Constitution, a detailed procedure is mentioned for arrest and detention. That if a particular person is arrested, he or she cannot be arrested unless they have been informed of the grounds of their arrest, number 1. Secondly, they have been given reasonable opportunity to defend themselves by virtue of or by way of indulging, or you can say soliciting, an attorney of their choice. So the person shall be given the opportunity to consult a lawyer of his or her choice. And thirdly, the person should have the ability, the person should have the, you can say, the opportunity to avail of bail as and when possible. And within 24 hours of such arrest, the arrested person has to be presented before a magistrate. However, if all this procedure mentioned under Article 22 of the Constitution is not followed, then the concerned person or any of the near relatives or friends can file the writ of habeas corpus in either High Court or Supreme Court. However, under Article 32, they can do so directly in the Supreme Court, where the court will then ask the administration or the authorities to produce that particular illegally detained person before the court. That is the writ of habeas corpus, to produce the body of. There is a second writ, that is the writ of mandamus. Mandamus has come from a word mandate, which means command. So in the writ of mandamus, the court actually instructs a public authority or an official to do his official duty. That is the writ of mandamus. Say there is a public authority who is supposed to do a particular work, but it is not doing it. So any concerned citizen can go to the court and get a writ of mandamus to be issued against that public official, which will force him or her to perform their rightful duty. The third writ is the writ of quo warranto. Quo warranto means by what warrant or authority. By what warrant or authority. That means if someone is illegally occupying a public office, which he or she is actually not entitled to or is not eligible for, then the writ of quo warranto can be issued against that person, and the person can be asked that tell us by what authority are you occupying this office. Now let us take an example. So whenever any exam result comes out, many such writs are filed generally. Say there is a person A who has got a rank 120. This is the rank of person A. And there is a person B whose rank is 121. There are a total of 120 seats in a particular educational institution. Now, say A was not offered the seat, whereas B has got admission. Right? So we are presuming that there is no quota, that there is no other rider. So all other things remaining constant, the one with the rank 120 has not been given admission, whereas the one with 121 rank has got admission in that particular institution. Now A will obviously feel bad. He will feel that his rightful seat has been given to someone who is less deserving than him. Now what A will do, A will file a writ of quo warranto in the court, and then the court will issue a notice to B and will ask B as well as that educational institution that on what authority B is holding this particular seat, whereas A, who is more eligible and has a better merit than him, deserves that seat. So then now B as well as the educational institution will have to answer the notice that has been served by the court. This is the writ of quo warranto. Similar things can also be done in case of government jobs and in other such areas. Then there is a fourth writ, which is the writ of certiorari. Now, certiorari is issued by the superior court to a lower court to ask the court whether it is certified to issue a particular order that it has issued. And then there is a fifth writ called the writ of prohibition, where the superior court issues an order to the lower court to prohibit it from exceeding its jurisdiction. So both the writs are of a similar nature. They are restraining the lower court from exceeding its jurisdiction. So these are the 5 writs that I mentioned under Article 32. And in CLAT 2020, you have got a passage on Article 32. In context of the freedom of press, In the Arnab Goswami case, this particular passage has been asked, that whether the writ petition filed by Mr. Arnab Goswami in the court stands or not. That is what the passage is about. So you have two passages which are directly from the Constitution of India. So I cannot stress enough the importance of Constitution of India as a law in your CLAT exam. And it cannot be a coincidence that both the passages that have been asked in the exam, one from Article 20, Clause 1, and another from Article 32, both of those are from the same part, that is Part 3 of the Constitution, which is fundamental rights. However, you should not always presume that since this is one of the most important parts of the Constitution, so you will always get a passage from this part only. I can tell you with conviction that most of the provisions of the Constitution are in news most of the time. So I, from my personal experience, can tell you that there is not even a single day's newspaper where no news is asked or no news is there from any part of the Constitution. Every single day, you can see news items directly linked to the newspaper. I can give you an example for the last few days only, or for the last 1 month, for example. There was a news in which Puducherry Lieutenant Governor, Ms. Kiran Bedi, has been removed by the president from her post. She has been removed by the president from her post as the Lieutenant Governor of Puducherry. Now here, the president is in news, the Lieutenant Governor is in news. Puducherry as a union territory with legislative assembly is in news. Again, the powers of the president can be asked. The role of the Lieutenant Governor can be asked. So anyhow, related to the Constitution of India, this particular news, you can expect questions. Similarly, we are seeing various state assembly elections coming up. Various state assembly elections. There are elections that are going to be held in West Bengal, in Kerala, in Tamil Nadu, in Assam. There are various states in which elections are being held. Now, in this context, the Election Commission of India becomes very important. In this context, the Model Code of Conduct issued by the Election Commission of India becomes extremely important, because these will be news. And somehow, not somehow, definitely, there are many persons who violate the Model Code of Conduct, and then there are complaints by the political parties. So this is in news every time an election is held. Then, in another news item, the Supreme Court of India, whenever it delivers a verdict. Now, since the Supreme Court is a constitutional body, you can expect any direct or indirect question from Supreme Court of India. The powers of Supreme Court, the composition of Supreme Court, the historical evolution of Supreme Court, and the role that it is playing in modern times. You can expect passages on this, right? There are so many things that are going on right now. Then there are certain authorities which are always in news. The Prime Minister, again a constitutional authority. The CJI, or Chief Justice of India, was also in news because of a defamation case. Then you have governors, which are always in news. Whenever they issue any controversial order, the office of governor is in news. The office of Speaker of Lok Sabha or of the state legislative assemblies is in news, mostly due to the anti-defection law. It has emerged as one of the hotspots of constitution, anti-defection law, because of so many instances of, you can say, maladministration as far as anti-defection law. This is going to be very important for you. And all these are very important for your law entrance exams, especially the CLAT. So yes, all these are important for your CLAT exams. Basically, if we undertake an analysis of all the passages that have been asked in CLAT 2020, whether it is the Constitution of India, whether it is the passage from Contract Act in which force majeure was asked, One passage was on principles of natural justice. Then there was a passage on hazardous chemical rules because there was styrene gas leak last year. So on that, they have asked a passage. So directly linking it with hazardous chemical rules. Then there was one question on mob lynching on the Palghar incident in which some religious men were lynched by the mob on the on the presumption that they were child lifters. So on that presumption, they were lynched. So mob lynching now directly, it's on criminal law. You have been given case studies, you have been given a situation, and then you are asked conclusions about it. So there are two things that become clear from all this. Number one, that most of the topics are current oriented. Most of the topics are current oriented. Right? This is the first observation that I can make. The second observation is that there are certain laws which shall always be important, which are always important, like the Constitution of India. You cannot afford to skip Constitution of India whenever it is in news. So I've just given you 4 examples of how Constitution of India was in news just in the last 1 month. You just open the newspaper of any single day and you will find at least 10 news items that cover various laws in detail. For example, for the last many months, we are listening about the agriculture reform bills, which we call it casually agriculture reform laws. Now, these are 3 laws, so you should know about those. Secondly, there are various activists, there are various, you can say, various protesters against whom sedition is being charged. The charges of sedition are being framed, again, directly from IPC or criminal law. You can expect questions on that. Then there are instances where freedom of speech and expression is in question. This is one topic on which you can find a news item almost every day in the newspaper. Freedom of speech and expression. Someday a book is banned. Someday someone speaks something defamatory to another person. So Article 19, Clause 1, Subclause A of the Constitution of India is directly or indirectly evoked in almost every such case. The freedom of speech and expression. You can expect a question on this. It is also from the Constitution. It is also from the fundamental rights part, and it is always in news. Then, for example, there can be certain new developments. Say a new right has been declared, which is quite a rare thing, but whenever that happens, you cannot afford to skip it. For instance, the K.S. Puttaswamy versus Union of India judgment. K.S. Puttaswamy versus Union of India judgment, in which right to privacy was declared a fundamental right. Right to privacy was declared a fundamental right under Article 21 of the Constitution. Right to freedom of life and personal liberty. Right to life and personal liberty. There are certain judgments which you cannot simply afford to skip. So, Constitution of India and all other laws which are in news are extremely important for you from CLAT point of view. And mind you, most of the topics are current oriented. They're not going to ask you anything out of the blue. And even if that happens, that is for everyone. The low hanging fruit for us can be if we do what is in news, if we at least cover those laws which are in news. So can you tell me in the chat section the name of any single law that you think is in news nowadays? Any law that you think is in news, and just 1 or 2 keywords through which I can understand that why it is in news. You can write that down. Meanwhile, I'll give you an example. For example, any new crime that has taken place, maybe a bomb blast, maybe a murder has taken place, maybe any other incident. Now, these incidents are there in the newspaper every single day. They can simply check, they can simply take up any of these issues and they can put it as a passage, and in the end, that becomes your case study. So in that particular scenario, you'll be asked analytical questions on that. That, okay, tell which section of IPC will apply here, or what kind of an offense it is, or which doctrine is applicable here. So basically, now all of you must agree that the newspapers are filled with crimes every day. So they can just simply pick up any of those paragraphs and they can ask you questions about that particular crime. And for that, we already have a code, which is the Indian Penal Code. So then this also becomes an important law. So after Constitution, second were the laws that are in use. Then third are Indian Penal Code, Criminal Procedure Code or CRPC, and Indian Evidence Act. Not entirely, because that you'll be covering once you get into the college, of course, but you should have an idea about these. You should try to link your preparation with these core areas of criminal law. Similarly, when it comes to civil law, CPC is extremely important. When you see the usage of terms like negligence, like some other technical jargons, you should actually be able to relate that with whatever news you have read. So when we talk about laws for CLAT 2020, the ambit is so wide, just like we have discussed right now. So it is a misconception that laws are only relevant for the legal reasoning section. You can see their overlapping effect on GK. You can see their overlapping impact on logical reasoning. And in fact, you can also see their overlapping impact somehow on English section as well. Because if you read so much, you're going to be in a position where you will be able to comprehend, you'll be able to understand large passages, your reading speed will improve, and that will definitely give you an edge in CLAT 2020. See, the purpose of the NLUs now is not to select like computers in which they can just feed the information and output will come out. No, the computers can do that. The human beings are better than that. So we not only should be able to give output, we should first be able to process that information with a very logical and rational mind. It is the gray matter which is at use here. So that is what I'm going to tell you. That is what I'm trying to tell you. So now the question arises how to go about it. Now that we have seen which all laws get important, how to go about it, how to prepare for these laws. Number one, you have to follow the current events. And mind you, these current events should not only be of national importance, they should also include the matters of international importance. They should also include matters of international importance. Now, I'll give you an example. Recently, the Minister of External Affairs of India, Mr. S. Jaishankar, made a statement that UN Security Council reforms are long overdue. That UN Security Council reforms are long overdue, and India should get its rightful share at the highest body in the world. Now, what is UNSC? UN Security Council is a principal organ of United Nations. It is a principal organ of United Nations. There are 6 principal organs of United Nations: UN General Assembly, UN Security Council, International Court of Justice, Secretariat, Trusteeship Council, and ECOSOC. So out of these 6, UN Security Council enjoys the most powerful position. UN Security Council is the most powerful principal organ of United Nations. However, it has 15 members, out of which 5 members are permanent, whereas 10 members are non-permanent. These 5 permanent members are there all the time. So in 1945, on 24th of October 1945, when United Nations was formed, these 5 members were the ones who won the Second World War. That's why, by position of their dominance, they kept themselves as the permanent members. Actually, there were 4, and later on China was added. So these countries are United States of America, Russia, France, and UK. These are the 4 permanent members, and later on China also joined. These are the 5 permanent members who hold a veto power at the UN Security Council. Then there are 10 non-permanent members who are elected world over for a 2-year term. And it is also in news because India has recently been elected to the UN Security Council from 1st of January 2021 till 31st of December 2022 for a 2-year term. And this is the 8th time India has become a member, or say non-permanent member, of UN Security Council. So those 5 members remain permanent, and these 10 members, they keep on changing as per the elections in UN General Assembly. Now, when Mr. Jaishankar made this particular observation, what he meant was that these 5 permanent members are not enough. They do not represent the entire world. There are various countries which are not adequately represented at Security Council, number one. Secondly, the Security Council needs to expand. Security Council expansion is what he actually took up at this particular meeting. Now, which law you should prepare? The UN Charter you should be aware of. When was the UN Charter signed? Since it is in news again, then any law or bylaw that you come across in this particular news item, UN Charter is very important, right? So you have to find out which events are in news. Like how to prepare, you have to keep a focus on current events. Say Motor Vehicle Acts was in news last year, when the prices of offenders, the fine amounts on offenders were increased drastically. So Motor Vehicles Act was in news. Then you can take any other example. You can take a law amendment is there, any new civil law amendment is there. You can simply go for it. But what are the do's? Confine your sources. Confine your sources. Do not just gather information from everywhere and anywhere. You have to confine your sources bare minimum. A maximum of 3 sources I would recommend. 2 to 3 sources is what I recommend. It can be a newspaper, it can be a good magazine, it can be a good blog, it can be notes, but it should not be more than 3, and prefer it should not be less than 2. Because if you follow from just one source, your sphere of preparation is going to be quite narrow. So try to cover at least 2 sources, good sources, and a maximum of 3 sources. Secondly, stick to the basics. Do not go overboard. You're not preparing for the law exams. You're preparing for law entrance exams. There's a difference between the two. You are not already in the law degree. You are preparing to get into the law degree. So do not go to that extent while analyzing a particular law that it becomes a burden. They're not going to ask you so deep which you are not expected to know. Because in law, since it's a professional degree, if you start going deeper into a particular law, there is no end to that. There are persons who have years of practice, years of teaching experience, and they have mastery or specialization over a few laws. So do not be that person who does that at the stage of entrance examination itself. So you have to stick to the basics. You have to structureize your preparation in such a way that you cover all the important portions of a particular law with special emphasis on that area which is in news. For example, if you are studying the Constitution of India, and in Constitution you are trying to study the office of the Speaker, pay special attention to anti-defection law, because the office of Speaker is in news because of controversial decisions on anti-defection law. That is important, right? So do's, you have to confine your sources to a few, and then you have to stick to the basics. You have to structureize your answer. You have to structureize your preparation. Sorry. Then the third do that I would tell you is to apply the knowledge that you have gained. Once you learn this particular concept, you can just start counting. You can just start, you can, the back counting towards your goal. Time countdown, actually. You can start countdown towards your goal once you learn to apply whatever you have learned. That is the most important part they're looking for. This is a very crucial part. Now, don'ts. So in don'ts, I will go in the same tune in which I have told you what to do. First, do not follow multiple sources. Do not follow so many sources that it becomes difficult to keep a track of all of those. Stick to 2 or 3 sources and just keep revising. Secondly, do not, I repeat, do not do anything new. Do not read anything new at least 3 days before the exam. Third, do not go for shortcuts. No shortcuts. So say someone is providing you printed material, someone is providing you a gist of a month's newspaper and anything. You can do that, but you should not only do that. You can do that for the purpose of revision, for the purpose of quick, like last time skimming of that particular notes so that you can be prepared just before the exam. You can use that for that purpose only. But if you skip the newspaper reading part, do not skip newspaper. It's a crime. If you skip newspaper, you are committing a crime. Which crime, I don't know. Just go and check the Indian Penal Code. But you're committing a crime. Not with anyone, but with your own self. So like when we classify crimes, we classify them into 3 categories. Crime against body, crime against property, and crime against reputation. This is how we classify crimes. So this crime that you will commit is against your reputation. It's against your mentality. You'll be mentally harassed if you do not, follow newspaper. So do not skip newspaper. I am repeating it again and again. Because if you do not read newspaper, then you will not be able to know which all laws are in news. You cannot simply rely on all the shortcuts. You have to apply your own mind. Apply your own mind. In the exam, things are not going to be in a capsule form. Things are going to be served to you raw. You will have to make your own conclusions out of that. For that, nothing is better than a newspaper. And do not forget, the one who bleeds, the one who sweats in practice does not bleed in war. So if you do not want to bleed in the exam, then sweat in your preparation. It's going to be very important. I know it is very boring. Newspaper reading is going to be highly boring for most of you, but this is the best investment you will make. This is the best resistance you will ever face if you want to rise, if you want to actually crack these law entrance exams. Right? So newspaper reading will improve your reading habit. And if you want to start newspaper reading, these are some pointers for you, for helping you. You have to fix a time of the day on which you will read it. You cannot simply say that I'll take 1 hour to read the newspaper. It can be any time of the day. No, it cannot be. You have to fix a time of the day. It can be morning, it can be afternoon, it can be evening, any time of your choosing. But make sure that there is clock work precision. There should be clockwork precision. Say every day you are reading newspaper 8 to 9 a.m. in the morning. So you do that from 8 to 9 a.m. If you change the time, it will lead to distractions. It will lead to indiscipline. Do not do that. Fix a time of the day. Unless you have become a pro, you have been reading newspapers for many years now, so it doesn't matter at what time of the day you read. No, you are still not in that position. You are novice at reading newspaper. So fix a time of the day so that it becomes a habit. Do not forget, the things that get scheduled, the things that get scheduled are the things that get done. The things that get scheduled are the things that get done, right? The things that you do not schedule are never done, right? So schedule your newspaper reading so that it is done every day without lapse. Then read hard copy initially. I know most of you must be thinking that, okay, we can read newspaper, we can buy the e-version of the newspaper and then we can read it from laptop, we can read it from phone. No, read hard copy of the newspaper initially, at least for a few months. Only then switch to a soft copy, that too if you feel the need to. Then you can maintain a vocab diary. Now this particular thing will help you in your logical reasoning section of CLAT. It will also help you in your English section. Not to say that it will definitely be helpful for your legal reasoning as well, because there is a terminology, there's a specific terminology in which they use jargons, the legal jargons. And if you read such crime and crime related news or some other laws which are in news, you may be well versed with such terminology once you're sit for the exam. And when you make a vocab diary, follow a particular technique. You can just write the word, like, let me write a word here. For example, jeopardy. So jeopardy means to endanger something or to put something into danger. That is to jeopardize something, to endanger. Now, this is the usual way of writing or making a vocab diary. How you can actually make it useful is the sentence in which you have seen this particular word, write that sentence along with this. So that next time when you're revising it, that sentence also comes to your mind. It will strengthen your association. It will make new neural pathways into your brain. And whenever you'll revise it, those neural pathways will become stronger and stronger and stronger. So I can tell you my own example. I used to make vocab diary and I made that diary for like 5 or 6 years. And now whenever I try to remember any of the words in that diary, I also, along with the word, am reminded of the sentence in which it was used. So that is the beauty of association. If you associate a thing with something, if you structurize it, the chances of remembering it becomes really strong. Say, if I tell you right now that if you do not read newspaper, your preparation is going to be jeopardized. If you do not read newspaper, your preparation is going to be jeopardized. You're endangering your own preparation. So maybe now you'll remember this word in this context. So when you read this in your new vocab diary, do read this particular sentence here, that in the class sir had told that if you do not read newspaper, your preparation is going to be jeopardized or you will be in jeopardy. Anyway, you like it. But it's a truth. Try to develop linkages with syllabus and previous year questions. Just like I have given you the example of Article 20, Clause 1 in the Constitution, Article 22 in the Constitution, Article 32 in the Constitution. Then there were, I also gave you the example of Contract Act, force majeure. I also gave you the example of the natural law, principles of natural justice. So now that you know the previous year questions, go through the syllabus as well, and then try to develop linkages. Try to see when and where and which provisions of the Constitution are in news. And believe you me, if you do this exercise religiously, you will be head and shoulders above your peers in these entrance exams. Right? So if you have any doubts, I'll take up your doubts now. You can ask me any question you want to, and I'll be happy to answer. Right? Meanwhile, let me introduce you to the team that we have. We have Harinder sir, we have Rajiv Markande sir, we have with us Ms. Jotpreet Kaur, who is the faculty of law, And we have Ms. Nitika Tiwari, who is in my department, the GK at Hitbullseye. So this is the dedicated team which will be working to make your dream come true. Okay, so I've got my first question. How much time we should devote on daily basis for this preparation? So it's a reasonable question, and considering that your board exams, most of you who are appearing in plus two this time, so considering that your board exams are also around the corner, I would suggest you that since the board exams are going to, I'm presuming that it's a CBSE. I do not know if you belong to any other board. So presuming that it's a CBSE and the exams are going to begin in the first week of May, I would suggest you that at least till the mid of April, till the mid of April, devote at least 3 to 4 hours every day on this preparation. At least 3 to 4 hours every day. Not less than that. So this is the optimum time. And once, of course, your board exams are over, then there is no time limit which you can devote for the final revision. For, then the more midnight oil you burn, the more fruits you will reap. That is what I can say. The time will be short, so you'll have to buckle up, you'll have to pull up your socks. This is what I can tell you. Any other questions that you have, I'll be more than happy to answer. All right. So thank you everyone for this wonderful feedback. And I hope you will, if whatever I have discussed today, if even 2 or 3 of you can take benefit from that, and you can be regular in following the news items, in developing linkages, in actually taking, taking benefit of whatever I have told you today, I'll be more than happy. Thank you so much and have a good evening.